Cheer Athletics is the largest all-star cheerleading program to date. Founded in 1994, the program is known for its many world champion teams. Some of their most notable teams, Panthers and Cheetahs, large all-girl and co-ed teams, being from the main location in Plano, Texas. On the very eve of what likely would have been a landmark trial in the sexual abuse lawsuit against Cheer Athletics Plano, the company hit the brakes. Instead of facing a jury, they filed for Chapter 11 bankruptcy, halting the courtroom and, with it, many of the unanswered questions. What if this filing wasn't simply a financial maneuver, but a strategic move to bury accountability? Today, we'll dig into the timing, the legal implications, and why this case didn't end up in trial. Because when courtrooms go dark, what happens to truth and justice? In the wake of the COVID-19 pandemic, the company shifted its business model and began franchising the brand in 2021. Since then, it's expanded to include many locations across the United States. Locations include Austin, Buffalo, Charlotte, Chicago, Columbus, Dallas, Denver, Emerald Coast, Fort Worth, Frisco, Lexington, Maine, Omaha, Philadelphia, Pittsburgh, Rochester, Rockwall, St. Louis, and their original main location in Plano, which is still company-owned. This franchising strategy became a major revenue stream. New franchisees paid an initial $75,000 franchising fee, and Cheer Athletics collects 10% of each gym's gross sales as an ongoing royalty. It's safe to say that these franchising fees constitute a significant portion of the company's income, providing much-needed cash flow as the organization rebounded from the pandemic shutdowns. Seeing as new locations have been showing up as recent as June 2025, the Cheer Athletics St. Louis location, this was clearly working for the brand. It's also important to note that legally, franchise disclosure documents confirm these fees and percentages, as all franchises must publicly report such financial terms. In 2021, Cheer Athletics found themselves facing a series of sex abuse allegations involving long-term coach Jason McCartney. Twin sisters Hannah and Jessica Gerlacher filed a $10 million lawsuit in July of 2021, accusing McCartney of sexually abusing them when they were minors training at the Cheer Athletics gym in Plano and Frisco, Texas. The twins were on Cheer Athletics Swoosh Cats in 2016 and also spent a lot of their youth training there even before they were world-eligible athletes. They would later cheer at Spirit of Texas on Royalty, A-Team, and Lady Rain. They have won majors, Cheersport, NCAA, and Worlds. The Twins' suit didn't only name McCartney, as it also named Cheer Athletics and USASF for negligence and failing to protect athletes. In the months that followed, at least 3 more former athletes came forward with lawsuits alleging that McCartney had abused them during practices. This included 2 women who filed anonymously as Jane Doe plaintiffs in late 2021, as well as Carrie Methvin, a former family friend of McCartney who sued in early 2022 claiming that she was abused as a child. All of these cases pointed to a disturbing pattern. McCartney had access to young athletes for years, allegedly using his position to prey on them, and the gym's oversight and reporting systems allegedly failed to stop it. Another important thing to note, Cheer Athletics has already resolved the majority of these lawsuits out of court. According to the victims' attorney, Michelle Simpson-Teagle, 2 Jane Doe cases were settled privately and other claims were addressed without going to trial, likely through confidential settlements. All of this to say, this left the Gerlacher sisters' lawsuit as the sole case that still headed toward a public trial. Cheer Athletics officials have denied any wrongdoing in the Gerlacher case. They've maintained that they were unaware of the abuse allegations at the time. They even claimed that McCartney was never alone with the athletes, a claim that the plaintiffs strongly dispute. The company claims that McCartney's interactions with the twins were limited to team practices and optional tumbling lessons, which the girls would have been in plain view of dozens, if not hundreds of athletes, coaches, and parents, according to the statement. In this instance, the Gerlachers never made Cheer Athletics aware of their allegations against Mr. McCartney during their years as athletes or in the nearly 6 years since they left the program, said Jody Melton of Cheer Athletics in the released statement. McCartney has also denied wrongdoing and is currently listed as temporarily ineligible on USASF's restricted and ineligible list. The key point is that, by 2025, virtually all the suits against Cheer Athletics and McCartney had been settled or dismissed, except one. The company's finances, therefore, were not broken by massive jury verdicts or unsustainable settlement payouts. Those settlements were handled presumably via insurance or manageable agreements. This undermines any notion that bankruptcy was a last resort due to overwhelming settlement costs. The Gerlacher sisters' case, the only lawsuit that had not been settled, was set to go to trial in a Texas state court in early November 2025. Jury selection was quite literally about to begin a Monday morning, but on Sunday, just one day before the trial, Cheer Athletics' flagship entity, Cheer Athletics Plano Incorporated, made its move. It filed for Chapter 11 bankruptcy protection. This Chapter 11 bankruptcy filing had the immediate legal effect of invoking an automatic stay, which froze all litigation against the company. In practical terms, the bankruptcy filing stopped the Gerlacher's trial in its tracks. The judge had to halt the proceedings because the federal bankruptcy law dictates that the creditor's claims, including lawsuits, must be addressed through the bankruptcy case rather than in separate courts. As WFAA News reported, the timing of the filing, literally on the eve of the trial, meant the two sisters were suddenly denied their day in court, at least for now. Their attorney, Michelle Simpson-Teagle, noted that the day before we were set to seat a jury for their civil case, Cheer Athletics filed Chapter 11, which stopped the trial from moving forward. Under Chapter 11, Cheer Athletics Plano says it intends to reorganize its finances while continuing operations. In a public statement posted to Instagram X and other social media platforms, the owner cited nearly 5 years of significant legal expenses and portrayed the bankruptcy as a strategic way to manage debt and strengthen our foundation, while still serving athletes. Seeing as the cheerleading community, for the most part, consists of younger athletes and people who don't have a grasp on legal terminology, the post was sudden and didn't make a lot of sense to young athletes. I'm hoping that providing context for the suit and defining Chapter 11 helps make the posts more understandable. Cheer Athletics emphasized that the filing only affects the Plano gym, which also houses corporate headquarters, and that all Cheer Athletics locations will continue normal practices and competitions during the reorganization. Financial disclosures in the filing list the Plano entity's assets as only $0 to $50,000 against liabilities between $1 and $10 million owned. Likely legal claims, attorney fees, and perhaps the new 70,000 square foot Plano facility's expenses. Around 1 to 49 creditors are listed, which presumably include the lawsuit plaintiffs as contingent creditors. So why file for bankruptcy now, right before the trial? Myself and many others argue that the timing was not a coincidence. Chapter 11 not only pauses lawsuits, it can also shield a company from the full exposure of trial evidence and testimony. Trials bring discovery, internal documents, emails, deposition of executives, and other evidence that would have come out in court, potentially becoming public record. By filing for Chapter 11, Cheer Athletics hit the pause button on discovery and depositions that were underway in the civil case. This tactic has been seen before in sports abuse scandals. Notably, USA Gymnastics filed Chapter 11 in 2018 amid the Larry Nassar abuse scandals, which stopped all ongoing civil litigation and depositions of USA Gymnastics officials at the time. As a result, USA Gymnastics never had to face public trial or extensive discovery about who knew what when. Instead, the claims were settled through the bankruptcy process years later. In that case, Michigan State University, Nassar's former employer, ended up paying a $500 million settlement to survivors, far more than USA Gymnastics' portion. Many saw USA Gymnastics' bankruptcy as a way to minimize its own financial payouts, forcing survivors to settle for less under bankruptcy court supervision. You might remember the viral impact statements given by gymnasts in the Nassar case, but it's important to recognize that these statements were a part of criminal court procedures and were not governed by USA Gymnastics' bankruptcy. The USA Gymnastics survivors at least had a courtroom and a chance to speak, even if the justice was imperfect. The Gerlachers won't even get that. Their case against Cheer Athletics may end before it even begins. No trial, no testimony, and no public record. Attorney Michelle Teagle explicitly drew parallels to such tactics in the Cheer Athletics situation. We've seen bankruptcy used in other sports cases to delay or avoid jury proceedings, she said. When a filing comes the day before trial, it raises serious questions about what's really being avoided. In other words, what damning evidence or testimony was Cheer Athletics so keen to keep under the wraps? A civil trial could have compelled gym executives or USASF officials to testify under oath about any past reports of misconduct, internal policies, and how McCartney was able to coach for about 2 decades. That testimony and evidence would have become public record, potentially exposing not just cheer athletics, but the broader all-star cheer industry's failures in athlete safety. By entering Chapter 11, cheer athletics places those victims' claims into bankruptcy court, a much more closed, financial-focused venue, where there likely will be a negotiated settlement and no public trial. For the Gerlacher sisters and any other remaining claimants, the bankruptcy means that they cannot get their day in court to seek full justice. Instead of a jury of their peers deciding their case in a public forum, their claims will be handled as financial claims in the bankruptcy. In practical terms, this usually leads to a settlement plan where the company and its insurance offers a sum of money to be split among the victims as creditors. The sisters' attorney expressed resolve to pursue their claims through the bankruptcy court process, but acknowledged that Chapter 11 is often a legal strategy to delay or avoid jury trials of these sensitive cases. It's a frustrating outcome for the survivors. The truth they wanted to expose in open court will likely remain sealed in mediation and filings, and any accountability will be monetary rather than the full transparency a trial could provide. As Teagle put it, bankruptcy can be a legitimate financial tool, but here it's being used to sidestep the justice process. The timing effectively deprived these young women of the opportunity to tell their story to a jury and have a verdict render public judgment on cheer athletics' actions or inaction. Instead, any resolution will come through a reorganization plan, essentially forcing the victims into settlement dictated by what the company can pay. Hopefully, the cheer community will continue to highlight the case and pay close attention to it, even though cheer athletics has allegedly attempted to shift focus from it. The bankruptcy court will sort out a reorganization plan and likely a settlement pot for victims' claims. Cheer athletics will aim to re-emerge on the other side as a functioning business. But the shadow of the strategic bankruptcy looms large. For the young athletes who sought justice, there is a sense of being robbed of full accountability. And for the sport of cheerleading, it's a stark example of how institutions can use the legal system to shield themselves when pressure closes in. The hope among many coaches, athletes, and parents is that despite this setback, the push for transparency and athlete safety will continue, so that no future cheerleaders have to endure what these survivors have, and so that those who allowed abuse to occur cannot simply litigate and reorganize their way out of answering for it.